It may seem counterintuitive that I am here today celebrating the 25th anniversary of the 1996 Hague Child Protection Convention. I'm in the United States, after all. I come here from a world without the 1996 convention. Yet I do celebrate this momentous occasion and am grateful to be able to share my uniquely American perspective on what I see as the essence of this private international law treaty. When I say essence, I am focused on one of the key reasons the United States signed this treaty in 2010, even though it has yet to proceed in ratifying it. That essence is the fundamental importance of having consistency between countries in recognizing and enforcing court orders that impact our children. Having this consistency is vital to ensuring stability for these children, dissuading parents from unilaterally relocating to other countries for sympathetic forums and laws, and giving families more clarity and certainty in how their family disputes will be resolved. While the United States may not yet have the 1996 convention, we actually have a fairly structured way of addressing this fundamental issue within our domestic law. And we do it in a way that respects the mobility of families in today's world. So today, I will share some of the US perspective on ensuring consistency for families in our legal system. Let me start with a story. A mother and father live in the US state of Maryland. They have a son. The mother is American, the father is Spanish. These two parents love and dote on their son. He has the best of all worlds. He spends significant time in Maryland and in Spain. He attends a bilingual school so that he is fluent in English and Spanish. He enjoys the snowfall in January in the mountains in Western Maryland and the warm sunshine during summers on the coast of Spain. When he is about 8 years old, his parents, for whatever reason, no longer want to be in a relationship. The father wants to return to Spain to be near his family. The mother does not want to leave her job in Maryland. Both want their son to be near them for his education. What do? They are at odds, with each wanting their son to live primarily near them. They, like so many families worldwide, seek the help of a court. Therefore, we come to our first question. What court in what country does this family go to for help? From a US perspective, I would say that these parents need to approach the family courts in Maryland, where this child was born and has primarily lived his entire 8-year life. Now, why do I say this? Every US state has its own version of a uniform law related to jurisdiction over a child's custody. Under this uniform law, Maryland is the child's home state, and the child's home state is the proper venue to resolve his custody and well-being. You may ask, what is a home state? Our uniform law defines it as the place where a child has lived with a parent for the last 6 months, excluding any temporary absences from that place, such as summer holidays to Spain. Now, what if the facts were reversed and this family lived primarily in Spain and spent summers in Maryland sailing on the Chesapeake Bay? Let's also assume that during the most recent summer in Maryland, the mother filed a custody lawsuit in the Maryland courts. What would happen next? Under the same uniform law, the Maryland court should conclude that Spain is the child's home state and that a Spanish court should resolve this child's custody. Only if the Spanish court decides it will not could the Maryland court consider resolving the dispute. This brings forward a slight twist in the laws and how US law intersects with the 1980 Hague Child Abduction Convention, which is ratified by the United States. If the mother filed her custody lawsuit in Maryland, with the intention of remaining in Maryland and not returning to Spain with the child at the end of their summer holiday, the father could use the 1980 Hague Child Abduction Convention by filing a lawsuit in the Maryland courts, requesting that his child be returned. The father, however, may have a separate second option to get his son back to Spain in this reverse scenario. If the father was able to secure a Spanish custody order and the mother had sufficient notice of the Spanish proceedings, the father could again use the US's uniform law, bring a copy of the Spanish custody order to the Maryland courts, and register the order so he can ask the Maryland courts to enforce it, presumably returning the child to Spain if that is what the order so requires. Our US uniform law has this streamlined registration process in place. And as you just saw with my hypothetical, a US court will register and enforce a foreign country's custody order under this uniform law without revisiting the order. As with any rule, there are some exceptions, but these exceptions are limited. The key limitation is how the foreign country had jurisdiction to issue its order. So long as the foreign court exercised jurisdiction under facts that would similarly afford jurisdiction to a US court, what our uniform law calls being in substantial conformity, there should be almost no question that our US court will accept the custody order. What does it really mean for a foreign country's jurisdiction laws to be in substantial conformity with those in the United States? To put it perhaps too simply, the child needs to have some actual, tangible connection to the place that is deciding his or her well-being. In most cases, that is the child's home state. But if there is no home state, then the uniform law looks for the location where a child has significant connections. It is not substantial conformity to let a parent file a lawsuit while on a vacation, ignoring the authority the child's home state has over that child. It is not substantial conformity to let a parent who abducts their child immediately file a lawsuit upon landing in that country. So while our terminology is a little different, in essence, our laws are very similar already to the 1996 convention's recognition that a child's habitual residence has the authority to take measures to protect a child. There is a difference, however, between the existing uniform law throughout the United States and the 1996 convention. And that difference arises when it comes to modifying an existing custody order. But if you bear with me, I want to explain a relatively important concept in our law. Our Uniform Act related to custody jurisdiction did not come about to address issues of international custody. That is merely a benefit of the way our act was drafted. Our Uniform Act was primarily written to address the fact that the United States is a massive country. It spans 4 time zones when you look at just the continental United States. If you add Alaska and Hawaii, then the extremes of the United States are 6 hours apart. It is faster for me to fly from Washington, D.C. to Amsterdam than it is to fly to Honolulu, and frankly, with better flight options. Parents move. They move for jobs, family, financial reasons, or for a new start after a bad relationship. Their children move with them. Since the US family law system is set up so that each individual US state, all 50 of them, and then our separate US territories have their own family courts, family judges, and family laws, it was important to provide for consistency and uniformity within our own country first. It was important to ensure that a parent did not move to the neighboring state because its laws or the temperament of his judges could give them a better result in their custody lawsuit. This is one of the underlying premises of the 1996 convention. It is no surprise that the current version of our uniform law was being drafted at the same time as the 1996 convention. To ensure that consistency, that uniformity, our uniform law puts in place a relatively novel concept when it comes to the jurisdiction where a parent can modify a custody order that they already obtained from one court. What if I told you that the father from my prior story was not from Spain, but was instead from Virginia, a state that borders Maryland? That child may spend significant time in both states. In some situations, depending on the towns in each state, one parent may live in Maryland and the other in Virginia, and the child could spend equal time in both states. If the Maryland Family Court issued the initial child custody order, and that child spent 1 week with his mother in Maryland and the next week with his father in neighboring Virginia, where could this family go if they needed to modify their Maryland custody order? And so is the concept of exclusive continuing jurisdiction. In our uniform law, Maryland would have the exclusive authority to continue modifying the custody order it issued until everyone left the state of Maryland, the child and both parents, or until the Maryland court determines that the child no longer has a significant connection to Maryland, and there is no longer substantial evidence in Maryland that relates to the child's care, protection, training, and personal relationships. How does this ultimately play out for an international family? It means that a US family court that issued a custody order may deem itself the sole tribunal that can modify that order going forward, even if the child is living overseas and even if the child has established a new habitual residence or home state. In other words, if our family litigated its custody case in Maryland and a Maryland judge ordered that the father could relocate their child to Spain, the fact that the mother remains in Maryland and continues spending time with the child during summers and breaks in Maryland means that Maryland courts could still modify the custody order in the future, even years after the child has begun living in Spain. Ideally, simultaneous lawsuits can be avoided. Multiple courts simultaneously applying their own standards to what is best for a child. Parents strategizing over whether they will participate in one or both lawsuits, or refusing to abide by the existing custody arrangement out of fear that the other parent may retain the child. These are the things we aim to avoid. One of the benefits of our US uniform law is its mandate for a US judge to initiate direct communication with its foreign counterpart to discuss this issue, because it is, after all, about the child. And even if a US court deems itself to have the authority to issue a child custody order, there are rules that permit the US court to decline to do so and to defer to the foreign court. This is what it is about: uniformity, deference, respect, and most importantly, a child. Having separate legal systems, both that intend to protect this child and do what is best for this child, working in tandem, having consistency between countries and recognizing and enforcing court orders that impact our children. So happy anniversary to the 1996 Hague Child Protection Convention, and my deepest regards for my colleagues at the Permanent Bureau of the Hague Conference on Private International Law for all of their tireless work promoting this treaty.